Good morning, everyone. My name is Robert Tauber, and I am the Regional Vice President of Southeast Florida. On behalf of Vesta Property Services, I would like to thank you all for taking the time today to join us. Today's webinar will be providing you as board members important information relative to this current situation involving COVID-19 and how to continue governing your association through these unprecedented times. Partnering with Vesta for this webinar is the law firm of McCabe Ronsman. McCabe Ronsman is a full-service law firm representing community associations throughout the state of Florida. It is my pleasure to introduce you to two of the firm's partners who will be providing you with this important information. First, Ed Ronsman, who is board certified in condominium and planned development law and has devoted his entire legal career to representing community associations throughout the state. Along with Ed today is James Roach. James represents community associations and developers focusing on providing general counsel legal services, as well as representing associations in contested litigation. So without further delay, I will hand over the virtual microphone to Ed.
Thank you, Robert. I appreciate it. Thank you all for attending. We have a lot of people joining in today, and we thank you for doing that. As Robert mentioned, we are a law firm that represents community associations throughout the state. We've been staying on top of this. This is the only area of law that we pretty much practice in, is representing community associations and keeping you advised as to the latest trends and what's going on and how we're interpreting the statutes and what you can be doing, or at least some advice that we can provide you in moving forward with these uncertain times right now. In terms of how we're going to proceed today, if you do see that it's being recorded, I just wanted you all to be aware of that. We're going to make the recording available. So if you have some board members or managers that aren't able to participate this morning, we're happy to provide that. I know that Vesta will be sending that out for you so that you can share that video. The other thing too, of just for the way that we're going to handle, we're happy to take questions this morning. If you look in your Zoom software, you can see a Q&A button. If you click on that and if you type your question out, we will see it. It will pop up. We'll likely proceed through our materials, our slideshow right now. And then if we can answer questions during it, we're happy to do that. And then we anticipate going through most of the questions at the end. So if you see your question and it hasn't been answered yet, we've been doing a series of these webinars with Vesta that we've been able to get through them. So if you can bear with us on that. But again, we really appreciate you being with us today. We have some updates even from when we presented this webinar to other areas of the state from earlier in the week because of the executive orders that have come out. So we'll be happy to discuss that with you. So moving forward here, I'm going to pull the PowerPoint up on the screen. If you'd like, after the fact, I'm happy to provide you with a PDF of the PowerPoint if you'd like to look at that. Also, we're able to provide you with a copy of the questions that were asked. Because we're going to be answering them live, you won't have typed out answers, but you can at least see the questions that were asked. So if you'd like to email me, my email, I think you should have it in your registration, but it is eronsman, R-O-N-S-M-A-N, at flcalegal.com, and I'd be happy to reach back out to you afterwards. All right, so the topics that we're going to be talking about today on these 5 bullet points. What is the community association's responsibility regarding COVID-19 and operating common areas and facilities? Altering, postponing, or canceling community events and meetings, updating cleaning and maintenance schedules, planning for possibility of shelter-in-place orders, but it's pretty much where we're at right now in terms of what the order is from Governor DeSantis. And I know that this is for the southeast region of the state, that especially Miami-Dade County has a pretty comprehensive order that is actually incorporated by reference into Governor DeSantis's order. So we'll talk about that. And then finally, we're going to talk about assessments and financial difficulties and some of the long-term effects that we can see coming from this because of the skyrocketing unemployment claims and people losing their jobs right now, and the impact this has had on the economy, which will impact your association from a collection standpoint for assessments. So we want to start out with the responsibility. The role of the board generally is to oversee the maintenance, replacement, and repair of the common areas and facilities and the condominium common elements. And so what that means is when you adopt your budget each year, one of the main items that you're always going to have is for common area maintenance. If you have any janitorial services, you're probably already providing that for your community in some fashion, depending on the type of community that you have, of course. We represent some associations that they don't actually own any property. Their sole function is to enforce violations and to handle architectural requests. So that may not apply for some of you, but for the most part, if you have common areas and facilities or common elements, you probably have some type of maintenance provision in your budget and or janitorial services that you may be providing for it. So that's already common for you to have it. However, how does this role that you have in your documents and some of the obligations for the association, how does that change regarding COVID-19 and specifically to prevent the spread of illness and disease? And I think this is one of the biggest questions that we've received is, what are we supposed to do? Are we supposed to, and you'll see we have a slide later on about cleaning schedules, but what are we supposed to do as an association during this right now? And I think that the best way that we can summarize this, that we've been advising our clients, is one of the best things you can do is to provide information to your owners as to what's going on with the property, what decisions you've made as a board regarding your common areas and amenities, and providing information on COVID-19, whether it's identifying symptoms, what you should do from a quarantine in place, if there's some recommendations there, but it's more of an information providing than it is necessarily a proactive role to try to stop the prevent of the disease. Now, you don't want to make it sound like we don't care about what happens to people. That's not what we're saying. But where we've been hesitant with our clients and their communications is you don't want to make it seem like when you're communicating with your owners that you are actively trying to prevent the spread of this disease by way of saying we are committed to slowing this within our community. We are committed to your health, safety, and welfare. Because when you start saying that, there's an assumption that you've undertaken a duty to protect your homeowners in a way that you may not have intended as a board or as a management company. It's not, in our opinion, it is not the association's role to go out there and to continuously wipe down anything that may be touched by owners or to otherwise actively prevent the spread of the disease. I think that's unreasonable to expect that of an association or even really a commercial entity. You know, if you go in there, they may be advising you that they've increased their cleaning schedules, but that's a commercial entity that wants you to come in and continue to do business with them, as opposed to an association where everybody may either have an ownership in the common, in the interest of the common elements, or have use rights over the common areas. It's a different relationship that you may have, and so we don't want our communities to undertake any additional liability unknowingly by presenting that type of communication. So one of the questions that we've received a lot is, should we increase our cleaning schedule? Should we close down this? You know, and the thing that you're going to hear from us today is we can't tell you if you're mandated on certain things. Although you are, for those of you in the Miami-Dade area, I know with that order specifically that it said that the pools and hot tubs and I believe the fitness centers are required to be closed, except as to if you own something like from a single family residence or an individual townhome usage standpoint. So there is a mandate in place from the Miami-Dade area. I know that is one of the more, I don't say restrictive, I guess, or mandates that have been put in place in terms of amenities that would apply to associations than anything that you find in the order from Governor DeSantis, for example, or for other counties. Our main office is up here in St. Johns County, up by St. Augustine and Ponte Vedra area. There is nothing in place from our local government in terms of requiring the closure of pools from a private or like a community association standpoint. So it does depend upon what your local municipalities are doing, but by and large, we're not seeing anything that's mandating that right now. So going into this, for common area and element operation, associations have emergency statutory powers. If you're a condominium association, it's 718.1265. For homeowners associations, it's 720.316. If you're in a cooperative, that's under Chapter 719. There are also the similar statutory authorities as well. If you need help finding that reference, please feel free to email me. I'd be happy to send that out to you. But the majority of community associations in the state are condominiums and homeowners associations. When you look at those statutory powers, they're very similar in terms of things that you're able to do now that there's a state of emergency that's been declared. Previously, these statutory powers have been used in the state of emergency after some type of a property damage event, typically from a storm or a hurricane or any type of a natural disaster that results in actual damage to the physical property. We don't have that right now, but we do have guidance from the state essentially stating that they consider these emergency powers to apply in the state of this with a pandemic going on, even though there may not be actually any property damage. And so we're going to walk you through some of those statutory powers and what you're able to do. But in terms of common area and common element operations, it would be on the next slide here that we're at, which is if you're going to make a decision regarding closing some of the common areas and amenities, you're probably going to be relying upon these provisions that are up on this slide. And the statute says that it's based upon the advice of emergency management officials, which has now been expanded to include public health officials, or advice of professionals retained by the association. The board may, the first bullet point is determine any portion of association property unavailable for entry or occupancy. And the second one is determine whether the association property can be safely inhabited or occupied. So what we've been saying, and Jim, if you want to touch on this a little bit, is determination of any portion of the property unavailable for entry or occupancy. I think that would be the basis for if you were to close down some of your common areas or facilities.
Yeah, that could be one basis that could support that course of action. And look, even if it's debatable whether you can exercise emergency powers under this circumstance, we think that you have the defensible basis to do some of those things, irrespective of whether they're ultimately deemed to apply. So yes, that's one basis, but even if we don't have to rely on that, we think there's a defensible basis, even generally, because you have control of the common elements and common areas.
Right. Robert posted in the chat that the Palm Beach County also has mandated all community pools closed this past week. So be mindful of that if you're in Palm Beach County. Now, we have to provide you a little bit of a caveat. We're assuming that all of these orders are valid and constitutional. You could get into a scholarly argument as to whether or not it's applicable, but we're going under the assumption that we need to comply with these and you as an association need to comply. If you have a strong opposition to it and are questioning whether or not it applies to your community, notwithstanding any order from the state or the local government side, please talk to your attorney about it and determine, there's a little bit more nuance and argument that can go into it. And if you are to, for example, keep them open, which we're not saying that we recommend that you do, just stating that there's an argument to be made for it. Before you do that, though, please get an opinion from your attorney. The thing that we like to say as attorneys is that when you get something in writing from us, you're essentially buying insurance. So if we're wrong, you get to sue us if we're wrong from our malpractice standpoint. But please utilize your attorney. We'd be happy to contact you or talk to your attorney that you've been working with if you're considering that. But we're going under the assumption that these local and state orders are valid in terms of a mandate and the closure standpoint. So going into this, again, restriction of common area and amenity use, it's on a case-by-case basis for your community, depending, again, on what order may be in place. There are factors to consider. Obviously, you're protecting the health, safety, and welfare of your residents, the potential liability of the association, and then the right of owners and guests to use the amenities. It's understandable right now with everything being closed from what I would call a recreational standpoint, beaches closing down, anywhere that you would normally go to maybe for recreation purposes, unless it's like an open air park that doesn't have entry points or something that the city or the county or wherever may have closed them down. I understand that people want to be able to use their amenities that they are paying assessments for example. But we do have mandates in terms of anything from a local or a state standpoint, and you do have the ability of the association to close these down. We are not telling people, if there isn't a mandate, we are not able to advise clients yes or no if you should close something down. What we're able to do is provide you with advice as to, if you were to keep this open, here's how we would recommend you do so and how you would communicate with your residents. For example, if you're still able to keep an amenity open right now for something that may not be subject to automatic closure, like a tennis court or a basketball court or something else that may not have been shut down, it may be advisable still to communicate with your residents that you expect people or ask people to abide by the social distancing recommendations and not having gatherings of more than 10 people, that the association is not otherwise providing for any increased, cleaning or sanitation or anything like that. Essentially, you are using this at your own risk. Even if we haven't closed it down, you are using this at your own risk. And I think that if you provide some communication, and really you're asking your owners and your guests and your tenants to be smart and exhibit common sense. But I give the tennis court an example because we had a community that closed down. They have a good number of amenities, including a clubhouse, a small fitness center. They closed down their pool, but they have a tennis court, and the owner said, look, I get everything else, but let me have my tennis court because you only have a couple people playing tennis at one time anyways. Let us decide if we want to be safe with that, but there's not a likelihood of a bunch of people gathering at a tennis court, for example. So if there isn't a mandate to close down, and I'm not aware from a tennis court or a basketball court or anything, if you are choosing to keep that open, I think that would certainly be defensible. But again, just consider the communication that you're putting out to the residents. Alternatively, if you are closing them down, we do think you have the authority to do that under the powers we just mentioned, under the emergency powers there. And again, it's just communicating with your owners and why that decision is being made. What we've been advising associations is that if the president has decided or directed management to close those down, I think that's appropriate, especially if there's an order that comes out or that's something that you feel like may require immediate action. But what we really recommend is to have a board meeting so that the entire board can discuss it and that the owners can participate in it. And we'll go into a little bit later regarding how you can have board meetings right now, but we've been advising clients that we feel like it's defensible to have a completely virtual board meeting where you provide some type of a call-in number for the owners so that they can still participate like they normally would, albeit by telephone, and then they can comment on agenda items. And we'll talk about that in a little bit. Let's see. So communication with residents, we started talking about that. Consider an e-newsletter or email blast with the status of the property and the amenities. You should advise owners and guests that the association does not guarantee the health, safety, and welfare, and that any use of the common areas and facilities is at the user's risk if they are still open. And you're going to hear us say this a number of times, and it's more, you can't stop yourself from being sued at any point. There's nothing that can prevent that. Anybody can sue you for anything at any time. What we're trying to do and what we're trying to advise associations is consider very carefully the communication that you're putting out so that it doesn't seem like you're undertaking an additional duty that you may not have anticipated when you were sending out that communication. There are a lot of personal injury attorneys that will be looking after this. I would imagine, depending on circumstances with different businesses and how they're operating, and if there's a proper claim that could be made, or at least to withstand, an initial motion to dismiss, for example, or something like that. Complaints will be filed on this if somebody gets sick and arguing that that business or entity should have done a better job of preventing it. Now, you might be asking yourself, how the heck can you prove that I got sick while being in my community association versus when I went out and got gas, or if I had to go get groceries or something like that? It's a great question, and we're not saying that associations, even that maybe do communicate that that they are committed to the health, safety, and welfare, and that it makes it seem like you're providing more services than you actually are. That's not to say that you'd be successfully sued, but it could be a better chance that you will be sued, because they can see that communication and say, boy, my client was sick, they stayed at home most of the time, and this community seems like they were trying to stop the spread, but they didn't. That means that they were negligent in their duties that they seem to have undertaken. And so I'm more likely to file a lawsuit and to name them in a lawsuit. Consider what type of insurance you have. I've talked to some insurance agents, I know we have a couple on right now, of whether or not your general liability policy may cover this. There may be an exclusion from a pandemic standpoint. But what is more likely to happen is if there's an argument that the board went beyond its obligation or breaches fiduciary duty in terms of being able to be named in a D&O claim, a directors and officers, that would trigger that policy in place. So again, you should hopefully have coverage for that, even if you are named. But what we're trying to do is limit the scope of liability, or limit the chance that somebody will decide to bring that by having careful communications with your residents. Jim, do you want to touch on anything else with that?
Yeah, or potentially reduce the value of the claim if they're ultimately asserted against the association. So, generally, to take a step back, landowners have certain duties to people that are coming on their property, and the nature of that person kind of controls the nature of the duty you owe to them. So just generally speaking, you don't have as high of a duty to protect trespassers as you do to people that, are either business invitees or other just social invitees, right? So the idea is, right now, someone could argue that you have, higher duties than we would like you to be deemed to have. But what we're suggesting is, in communicating with people, provide notice and reference other governmental organization recommendations, but try to keep things out of your communication that could be argued by someone looking to seek compensation under these unfortunate circumstances. try to leave things out of your communication that might make it easier or make that claim more valuable or make it easier for someone to argue, hey, they might have not otherwise had a duty to protect people or prevent disease transmission, but they specifically undertook such a duty by sending this communication to everyone purporting to express that they did undertake that duty. So it's just being equivocal. You can express sympathy without undertaking a duty or having language that someone could argue that you have.
We just marked a question as answered, and it was related to that, where if you don't close the pools, somebody contracts coronavirus and dies after they had gone swimming in the pool, could the association be liable? I think that in that circumstance, they would probably look back to see where were they at the time. You know, it's from a proof standpoint, I would think it would almost be virtually impossible to be able to actually prove that. But if you can say, hey, we never left the community, but we used the pool and there were no warnings or something. Now, could the association be sued? Yes. Do I think that there would be successfully sued in terms of going all the way to a jury? I would have a hard time seeing that. But if you're talking about the way that you're communicating to residents, the more that you can clearly communicate that you're using this at your own risk, if you are able to use it, for example, that would decrease, you know, the value of the claim or the likelihood that somebody were to bring the claim or an attorney to find that it would be a valuable claim. You know, an attorney might say, look, this community was pretty proactive in letting you know that this is closed, or if it's not closed, that you're using it at your own risk and that we're not undertaking any additional cleaning. They may say, look, this might be a more difficult claim for us to bring on your behalf. They still may say, look, you should have provided additional cleaning, and we can defend that claim, because I think it comes down to there's nothing saying that we are required to go out and wipe down every surface after anybody ever touches anything. You know, I don't think that there's that standard, but you don't want to make it seem like you've undertaken that duty to then say, we've undertaken it, but we didn't live up to it. That's what we're trying to prevent against.
Yeah. And the potential for liability exists. How a jury, if it gets that far, would ultimately determine that kind of case is uncertain. And because of that, we're recommending some mitigating measures.
And Jessica has posted a point here that says Miami-Dade has a stay-at-home order and all those things, including tennis courts, have to close. I was aware from the pool and the hot tub and the spa center, I wasn't aware that they closed down tennis courts that were for community use. So obviously, get in touch. If you're a board member, you're not sure, get in touch with your manager, get in touch with your attorney to see if these local orders apply to you or not, and really look at the wording of that too. You may, at first glance, it may seem that it applies to you, but it may not. It depends on the reading of it. So again, that's where working with your attorney and your manager is valuable in this. If you feel like there's something that you can keep open because your residents are asking for it, you feel like you can provide proper notice to let them know that they're doing so at their own risk, for example.
Yeah, and even now there's a question, given that very recent order from the governor, to what extent local governments can actually make things more restrictive than that state, executive order does.
Yep.
So where that might have been applicable before, maybe even 2 days ago, now it's in a little more of a state of uncertainty.
And we should, let me see, I think this would be a good point to talk about that. So you have two orders that have come out. As everybody knows, Governor DeSantis on April 1st issued an executive order essentially asking for 30 days, requiring people to stay in place, and then unless it's for an essential activity. And there's some definitions of essential activities by way of, he's basically incorporating by reference some federal, I think some federal guidelines, as well as really the Miami-Dade and the Broward orders. And so, and basically incorporating that by reference. There is a provision in there, though, that said that it conflicts, any local order is invalid if it conflicts with a prohibited activity in the order. And we had some questions about what that actually meant. Does that mean that he didn't really prohibit too much in the order? Actually, it more said you shouldn't do anything unless it's an essential activity. Here's what an essential activity is, but there were some questions as to what was a prohibited activity. Then an order was issued yesterday, which basically said that any local order, this supersedes any local order to the extent that the local order conflicts with this one. That it kind of simplifies it a little bit. And where I've at least seen, or at least some of the discussion on the news, was in the first executive order, he said that religious gatherings are still allowed. And so some local municipalities have exempted religious gatherings. Have said that should not be allowed. So I think that part of the intent was to say, hey, local municipalities, you have to allow religious gatherings, notwithstanding what your local order said. At least that's some of the interpretation that's come out in the news on it. But again, like Jim said, there was nothing in the executive order from Governor DeSantis that said that you couldn't use your community amenities, for example, So I think there's still some question as to the validity of some of the local orders versus what the state order was on it.
Right, and particularly, the state order from the governor says that recreational activities are deemed essential, such as walking, biking, hiking, fishing, hunting, running, and swimming. So the question is, okay, the governor, you say swimming's okay. Well, how do we swim if our local jurisdiction is purporting to make us close all our pools? Where else is there? I mean, in our bathtub, where are we going to swim, right? So there's some significant questions to what extent local ordinances are going to apply in this circumstance.
And that was issued just yesterday. There hasn't been further guidance on it. There may be some questions. I'm sure a lot of you may have questions as to, well, if we close down pursuant to the Miami order or the Palm Beach County order, whatever other order, and they've closed down your community pool, and now you have this, you got, what we're hearing from you, Ed and Jim, is that maybe we don't have to close it down because the Governor DeSantis's order didn't close them down. It's a good question. I think that we'll see some clarification on this, but if you decide to keep it closed, I think that's defensible regardless, because of the way that the statute is written, that you have emergency powers to deem any property to be unsafe for use. If your local municipality has said close down the pools, and now there's a question though whether or not they could actually require it versus what Governor DeSantis says, and you've decided to rely upon that, I think you would be perfectly defensible, and I think you could withstand a challenge or strongly withstand a challenge from an owner that said you should reopen the pool. So where we're coming from is, are you required to? I think there's still some question now because of the executive order from Governor DeSantis versus the already existing local orders. But if you choose to keep them closed, I think that that's defensible based on the emergency powers that are available right now. Going in on the last bullet point, it kind of goes into the next slide, which is you should continue to have board meetings. Notice can be provided by alternative means. That's one of the first things in the statute that says that, and again, it kind of eliminated the standard 48-hour notice requirement for board meetings by saying you should notice meetings in a manner as practical as possible and by alternative means in the way that the board deems fit under the circumstances. But again, that's more coming from if you had, I could see that more if a storm is bearing down on us and landfall is going to happen in 48 or 72 hours, and you have an emergency meeting to decide whether or not to order an evacuation, which you're allowed to do for a condo association specifically, that you want to have a very quick meeting and give notice for as much time as practical, but definitely not 48 hours. For this, we don't really have anything bearing down on us. There's no damage to the property. So I would think in most cases, you probably should still provide your 48-hour notice, unless there's something that you feel like you have to take action because of a federal, state, or local mandate that requires a quick meeting. But still, you should post your notice in whatever way you can, whether it's on the property and then sending out an email blast so that the members are still aware of it and that they can participate somehow. And going into the next slide here, we talk about board and membership meetings. In the emergency powers, it doesn't specifically say that you have the ability to hold a completely virtual meeting, but we've been advising our clients that we think that that's defensible. If you were to post or otherwise mail or email or provide notice in whatever the best way is possible, saying we're going to have a meeting on this date and time due to the stay in place order and the recommendation against any gatherings of more than 10 people, people sitting within 6 feet of each other, that sort of thing. We are having a completely virtual board meeting. Here is the conference line and PIN number. We encourage you, if you'd like to participate, you can call in that way. And then everybody can be virtual. Nobody is close to each other. And then the board would conduct its meeting and conduct business, and then owners could comment like they normally would on an agenda item for 3 minutes. But it deviates from the requirement in the state statutes, which says that you're supposed to, in the meeting notice, state the date, time, and location. And location basically means some type of physical location. Well, you don't have that now, and it's not in the emergency powers, but we've been advising our clients that we think that that's defensible. And because I think it's the alternative of nobody's going to want to have a board meeting where people are required to sit next to each other and be in a space that's not safe from a health standpoint. You can even see Jim and I'm kind of speaking this way, so I'm not too close to him, it's not practical or advisable to have a physical location. So then the question is, well, do we not have meetings and we have our boards email and vote on things, which is a no-no under the statutes. At least, there has been guidance that has come out that says that boards may not vote by email. That's specifically in the statute now. I think that if challenged, I'd rather be able to show that we had a virtual meeting rather than emailing where members couldn't participate. So that's what we've been advising our clients on. But the question is regarding membership meetings. Membership meetings are able to be canceled and rescheduled, but we have not been recommending that associations try to have completely virtual membership meetings. And it's because of the nature of membership meetings where members, that's their opportunity to vote, if it's to show up in person and to cast their ballot if they forgot to otherwise mail it in or send in their proxy. Whereas board meetings, you've always been able to attend as a board member a meeting telephonically and vote over the phone. That's always been your right as a board member under the state statutes. Whereas there is no way to complete, like if I were a member that called into a virtual meeting, there's nothing that allows me to vote yay or nay on an issue by way of state statute right now, which is why we've been advising against completely virtual membership meetings. You could have that one owner that says, I forgot to send it in, but I anticipated that I could walk up and sign into the meeting and drop off my ballot the day of. If you don't have a physical location, that prevents me from doing that. So most communities have been completely, of course, been canceling any meetings that have happened in late March or going through April. The question then is, do you have to renotice the meeting from scratch if you're a condominium or a cooperative that has the 2 notice requirement for annual meetings? Or can you resend out the second notice or pause when the second notice goes out? And that's one thing that we've discussed. Jim, do you want to touch on that a little bit?
Yeah, so we're trying to draw a line between board meetings and membership meetings. And we think there's a little bit more room for flexibility and defensibility of maybe some tweaks to the processes for holding board meetings. But for membership meetings, is there technically a way that we could, come up with a quasi-virtual process while also satisfying technical statutory requirements for having a physical meeting location? Sure, there's a way to do that, but we don't really think it's worth trying to reinvent the wheel for this one situation. We think, what's best right now is just postpone those meetings for now and reconvene them at a more appropriate time. So one of the main questions is, okay, well, guys, this caught us right between our annual meeting and election. We sent out our first notice, we got all our candidate forms now, and we're getting ready to send our second notice. What should we do? Are we going to have to do this all over again if we don't do this right now? And what we think is, under our current circumstances, if you've already done your first notice, if it caught you in that circumstance, postpone your meeting to a later date so people don't have an argument they didn't have the opportunity to participate. And so, you're talking about the question, how long can the election be postponed?
Yep.
Yeah, so I'll get to that too in just a second. So if it catches you between your 2 meeting notices, we think that you will ultimately be able, and it will be defensible for you to just send your second notice out, because we totally get it. I mean, if you have a large community, it's expensive to mail all this stuff out and then have all the ballots come back in, and are you going to reopen the candidacy again? So what we think is, under the circumstances, you should be okay and it's defensible if you just pick up the ball where you left it and go with your second meeting notice at a time that's going to be, a little more reasonably safe than our current circumstances. And in terms of how long can the election be postponed, so many of you have governing document provisions which will say, hey, it must be on the second Saturday of April, every year, or it might actually say a specific day in your governing documents, or it might not. It might say, you must have an annual meeting and election at a date, time, and location determined by the board. So in the Florida For-Profit Corporation Act, which some of you may be for-profit corporations, some of you may be nonprofit. In the For-Profit Corporation Act, there's a statute specifically providing a right for members to petition a court to mandate that your corporation hold a meeting if an annual meeting of the membership isn't held within a 15-month period. Again, that's only in for-profit corporations. Whether that would be deemed to apply to also nonprofit corporations, could be debatable. But we think, from a practical standpoint, a lot of your members should understand the situation you're in, and they should be appreciative of the fact that you're not forcing them to participate in something that might not be a healthy thing to do at this time. So we don't think people are going to run to court and look at that 15-month statute. So I would say, to directly answer your question, try to do so as soon as it's reasonably safe to do so, right? And it's we're going to keep monitoring the situation, and so I can't give you a date of when and how long you can do it. That can be somewhat governing document dependent, but probably not now, and at a reasonable time, as soon as you
proxies, can. The validity of the proxies.
Oh, so yeah, that's another good question. One issue associated with your membership meetings is many of you send out proxies and have people attend that way, so you can either get a vote on an issue by limited proxy, or to attain your quorum, right? And depending on whether you're a condo or an HOA and what your election procedures provide for in an HOA context, you might need to attain a quorum to get, for your election to happen. Well, one issue is, for a proxy to be valid, The statutes don't require a whole lot, but what they do require is that the date, time, and location of the meeting be indicated in the proxy. So if you have to, if we caught you in the middle of an election and your proxy had the date, time, and location of the originally scheduled meeting and you need to reschedule it, well, then there's an argument regarding the validity of your proxy. So in addition to not having that content in your proxy, also proxies are generally valid for the meeting for which it was given and for 90 days after that meeting for which it was originally given. So if you fall without that outside of that 90-day window when you reconvene, or if you're concerned about a potential argument with the proxy not including the accurate time, date, and location of the meeting, then the most conservative course of action is when you send that second meeting notice out again, go ahead and send another proxy out and get them to send that back.
Right. Yeah. Let's see. I think we had a question here. I think it must have been just addressed regarding annual meetings. Okay. So going into cleaning and maintenance schedules, we talked about this earlier. The board has discretion in whether to increase the cleaning and maintenance schedules. As I mentioned earlier, you already have probably in your budget, for maintenance, replacement, repair of the common elements, the amenities. If you're already providing for cleaning, if you were to choose to increase your cleaning schedule, I think that would perfectly be defensible under your existing authority under the governing documents. What I wouldn't necessarily recommend doing is taking the next step to advertise that to the owners to say, hey, by the way, we are increasing our cleaning schedule by 3 times. Instead of having once a week, we're having 3 times a week or 4 times a week, whatever it is. By communicating that, it's sending a message that you are proactively trying to prevent the spread of the disease. If your main goal as a board is to try to protect people, I think you can do that, I'm not saying silence, but in terms of just by increasing the schedule without necessarily having to tell people. Because if you tell people that you're doing that, it may make them think, well, okay, they're increasing the cleaning. That means I can go out more. That means I can maybe have more gatherings or be closer to people because I know they're doing a better job of cleaning it. It might send the wrong message. I say if you're going to do it, go ahead and do it. And I think that you're probably authorized under your documents to increase that schedule, and it's a valid common expense. I just would be careful about how you're communicating that you've undertaken that. So again, you're balancing the line between administering your duties under the governing documents and warranting the safety of residents. Again, if you do have anything regarding if anything's closed or if you keep it open, for example, like if you have bathrooms that maybe, I'm trying to think if you would keep bathrooms open as part of around your amenity areas. If you're not closing those down, just have disclaimer language there. We've been recommending to clients just post some flyers from the CDC website in terms of, proper hand washing techniques. You are recommended. I wouldn't say anyways that you're requiring it or that, that you're otherwise undertaking that duty again. Just say, here's what's recommended from the CDC. Like I said at the beginning, the best thing that you can do as an association right now is to provide information and resources, but not make it seem like you're otherwise maybe mandating something or taking on a duty you didn't anticipate that you thought you were doing when you sent out that communication. Shelter in place orders. So we've talked about this kind of throughout already. Be mindful of that from federal, state, and local mandates. We have that now with the executive order from Governor DeSantis, which runs through May 1st, if I remember right, 30 days from April 1st. There's probably gonna be some questions that come out, especially in counties that you may have some provisions in the order that may be more restrictive than what Governor DeSantis has included. So be mindful of that if you are required. But as Jim and I have said before, even if you might not be required to keep those closed, or if there's some interpretation on that, if you choose to do that, I think it's defensible under the circumstance. And it's just a matter of communicating to the homeowners about it. The big thing is, and some of the questions we're receiving is, well, if we have this shelter in place order, if we see people out there, what are we supposed to do, or how do we prevent this? And our answer is contact law enforcement. If it's something that you can forward on to law enforcement for them to handle it, do that. It would be like, even if we weren't in this pandemic with a shelter in place order, if you had a trespasser on the property, we would never advise you to go in and try to break up or try to physically remove them. The first thing we tell you all the time from a board standpoint and from a manager standpoint is call law enforcement, let them come out there. Depending on where you're at, sometimes law enforcement, they'll come out and say, well, this is a civil issue, we can't really get involved with it, but hey, they may say something to them to at least get them to go home. And when you see, an officer come out, that people may take that more seriously, but don't try to insert yourself physically in it because you don't know how people are reacting throughout all this, and we advise against that. the biggest thing is, there may be some things you can do to hit their pocketbook after the fact in terms of a fine for a violation. Some communities, they've said, well, what can we do, Ed, if we can't stop them from being there and congregating around our pool, even with us closing it down, and law enforcement won't do anything about it. And I said, well, I think you could potentially pass a rule that more closely tracks what orders are in place right now if you're restricting amenity use and considering it a fine if they're in violation of that. But that's more of an after the fact type thing. It doesn't stop them in the moment. It may stop them if you communicate with them and say, we observed this. If you continue it again, we're going to levy a fine, and we're going to set up a meeting at some point. And even when we get out of this, we're going to impose a fine against you. And I think that could be valid, but it doesn't actually, the actual effect of removing them right now. So that's where there's some difficulty. Jim, did you want to touch on that a little bit?
Yeah, and I think the main point there is part of understanding what your role is. So it's not your role or responsibility as the board to enforce law, right? And these executive orders, they're directed at their law, and they direct law enforcement to enforce them. So, again, to parrot what Ed said, don't put yourself in a position as a board member, officer, or manager and confronting people personally or physically. It's one thing to send a communication to someone to say, hey, we closed the pool down. I saw you used it. Please refrain from doing so. We're trying to, follow CDC recommendations and so forth. But I wouldn't go much farther than that. The tool to get to have the law enforced is call law enforcement. Otherwise, you have some after the fact tools to, punish, so to speak, the activity. But again, if the idea is to get people to stop doing it now, call law enforcement to do that job.
Yeah. Okay. And then going into our last slide, and then we have some questions that are queued up here. Assessments and financial difficulties. So what we're going to see from all this is, if you've all seen the unemployment numbers, how they've been skyrocketing. I think between last week and this week, there are 9 to 10 million new unemployment filings. That's going to have an impact on your communities, because what that means, of course, is people don't have income. They've lost their jobs, at least for temporarily, potentially, however long this lasts, which means that they're probably not going to be paying their assessments at some point, or they may be more difficult for them to do that. And so if for those of you that were around or on your board back in 2008, when we had the housing crisis and the recession that came out of that, with the number of foreclosures that jumped up and everything, it's important to have a collection policy in place, or at least be mindful of it. I wouldn't deviate from anything that you're already doing right now. That's one piece of advice that we're giving to our clients from the standpoint of, we had a question yesterday when we did this webinar, which was, should we advise owners that we're delaying I think they had a twice annual assessment. The next one comes due on June 1st or July 1st. And they said, should we delay that? And we would advise against that, because these assessments, of course, are your lifeblood of your community association. And you operate on a budget, presumably, where you come up with your expenses each year, and that's your first thing that you do. And then you say, okay, we have $1 million budget for expenses. How are we going to get that $1 million? And that comes from your assessments. So anything less than $1 million that you collect is going to make it hard for you to stay within your budget, of course, and make sure things are paid for. So that's where the difficulty is of trying to suspend or have a blanket policy already on delaying collection of assessments. I would stay the course with it. If owners contact you with hardships, I think you can analyze those potentially on a case-by-case basis, and see if you, maybe for the time being, you suspend late fees and interest, or if you find yourself receiving a lot of these. I've had some communities that have thought about, well, if you become delinquent starting on April 1st or May 1st or something tied to the downturn, then the board would consider suspending late fees and interest or altering its collection policies, as opposed to somebody that's been delinquent for a year now. I mean, it could be used as, I want to say an excuse, but it could be used as an excuse. But really, they've been delinquent for a year. It's not because they've just lost their job a month or two ago. It's because there is something else going on. So I think that depends on how your community is going to handle it. Some communities have just said, hey, we don't want to have to try to differentiate. We're just going to eventually suspend late fees and interest. I would talk with your manager, talk with your attorney about that. There's some ramifications from the standpoint of, you don't want to give away something like, if those owners go through foreclosure, and hopefully that doesn't happen, of course, right? But if properties are sold, or if they go through foreclosure, the association almost always has the right to collect at least a portion of those back due amounts. And some of you have gone through this, where banks have limited liability, depending on if there's a mortgage foreclosure. But if there's a proper charge, you don't want to waive that before the foreclosure actually took place. You don't want to let them point back and say, well, it looks like you suspended late fees and interest, or you wrote off some of the amount, so you can't demand that we pay that now that we've taken title. That's where you want to avoid any type of blanket policy, at least for the time being right now. Or if you do have some type of policy, it can be conditioned on, we're not waiving these for good, but as long as you continue to make this payment, we'll eventually waive it, or something like that, where you're still able to eventually potentially charge for it. Now, I know that sounds kind of harsh, and we're not trying to make it sound that way, but we're really trying to protect associations from instances where those owners are unable to pay and they lose their property, that we still have the tools to collect from an investor that comes in or a bank that comes in to be able to charge them for it. So I would avoid anything from a suspension of a collection policy. We're keeping track. There was just an order issued. Jim, you want to talk about that order on the foreclosure side?
Yeah, definitely. And what we're talking about really here is sending any communication prospectively waiving late fees and interest in the future. Our suggestion is, let's look at some hardships on the back end when people contact us in response to collection letters later on, and consider them then, rather than sending something on the front end that might ultimately be able to be used against the association by a financial institution or investor later on, because that's not who we're trying to help here. So in terms of the order that was just issued yesterday by the governor, so the governor purported to suspend and toll mortgage foreclosure actions for 45 days, or unless suspended or extended again by the governor. So this order is so new that this is the first time we're actually even talking about it. And it's interesting how much our conferences have evolved even this week, given how much purported law is being established on a daily basis. But as we're sitting here right now, we have this new order from the governor, this new executive order purporting to suspend mortgage foreclosure actions for at least a period of 45 days. Now, there's some argument and debate about whether that would apply to association lien foreclosures. And we think that from a practical standpoint, a lot of local jurisdictions and clerks' offices are going to try to interpret this broadly. So in addition, it also suspended eviction causes of action. So there's some arguments as to what the words actually mean and how it can be interpreted. But the bottom line is this: we're going to see likely some more government impediments or impairments, if you will, to your ability to collect money that you need to operate, pay your insurance, and pay your other vendors anyway. So we're trying to say, let's avoid some self-imposed moratoriums, if you will. We think the government might impose some moratoriums or attempt to do so anyway. There's room for empathy in this situation, but it needs to be calculated. And we don't, again, our goal is to not let investors or financial institutions take the benefit of some things that you've tried to do to benefit, your average Joe homeowners.
Yeah. The other thing, just from a collection standpoint, the third bullet point, there are no emergency powers to use reserves for operating expenses, requires membership vote. This is a question that we received a couple of times. You may have a healthy set of reserves and you may not anticipate using that money this year for projects, which means that it's not like you have 500,000, but you're going to have to use 400,000 in the next month or so because you have a project plan. There have been some questions. Well, if we get into some difficulties with collecting from owners, can we use some of that money to help with our operating for the time being? Or we had a good question yesterday, which was, when your assessments come in, can you put all of those assessments into the operating account and then later in the year catch up your reserve funding from your monthly assessment amounts? And it was a good question, but there's a statute on point for that, at least from a condo and cooperative standpoint, if I remember right. I know it was for sure for condos, which says that within 30 days of receipt of money that's earmarked for reserves, it has to go into the reserve account. So we can't get around that you have to make sure, and the example that I give, if you have a $300 monthly assessment, and based on your budget, $270 is for operating and $30 is for reserves, that $30 per owner has to go into the reserve account within 30 days. So that was a creative question. But it's not allowed, at least now, for the way that the statute reads from an emergency power standpoint. And also, reserves have to be used for their intended purpose. There is, and that's by law for condos, HOAs, and co-ops, which says that reserves are for their intended purpose. And if you want to use them for other than their intended purpose, you have to have approval of the membership, and it's majority of the members approving it at a meeting where a quorum is met. So it's not of your entire membership, it's where a quorum is met. So as long as you make your quorum, which may be 30% or less for HOAs, or whatever your number is for condos, at least a majority of the members, It's a majority of those appearing in person or by proxy, not of the entire membership, but you still have to go through and obtain that vote. So that's the difficulty there. There is some financial relief from the standpoint of the emergency powers. Even if your documents might otherwise require a member vote to take out a loan, the statute says that you can take it out notwithstanding any requirement for a membership vote, and then you can pledge collateral on behalf of the association to be able to take out the loan. So that is something that's in the statute contemplating financial difficulties, but it doesn't go so far to say that you can start using reserve money. So be careful if you're considering doing that, or if you're faced with, you might not see it right now because people may have not had to make the decision of whether or not to pay their assessments yet, but it's going to be happening soon, or may have started on April 1st, and you may see it in the next couple of months, that these are going to be some issues that you're going to see down the road, 3, 4, 5 months from now, if people stop paying their dues starting this past month or in the next quarter, whatever it is, and you now find your AR report creeping up with a number of owners that are at least 30 days delinquent or whatever. And so I think it's important then to work with your management company, work with your legal counsel. We handle this all the time in our law firms, unfortunately, of having to help out communities with collection issues and developing the best policies for you. So utilize your team that you're working with to help you get through this process. But the main thing, if you want to have a takeaway from this, is we're advising against any communication of saying, hey, don't worry about paying us your assessment right now. I would hold off on that. Let owners contact you individually, and then see how the response is from your community and how your members are doing, and then determine if you eventually want to have that or have some policy in place as a suspension of late fees and interest, or establishing payment plans or something like that. But I wouldn't do that proactively right now. All right, so with that, I'm going to go through. We have some questions that I'll be happy to answer here real quick. Ed, good name, by the way. Things are moving so quickly. Some communities have closed themselves to outsiders. I would like to see that. What is your take on that? It's a good question. And I know we have some variation of that question in a couple of these here. It's a difficult thing to say you want to, again, protect people and seeing the shelter in place order. But when you look at the essential services, there are a lot of businesses that are considered to be essential services. For example, just upon first glance, I saw that residential and commercial landscaping was an essential service. I think I saw anything from a construction standpoint was still deemed to be an essential service. So there's a lot that may still allow, when I read these orders, this is my personal take. I drove into work today. We have just a couple of us. Actually, Jim and I are the only two in our office today. Everybody else is working remotely. I still see people on the road. I think the intent is to try to limit as much as possible social gatherings, having people, really keep people home as much as possible. But there is business that's still being conducted right now. And it's a difficult decision to make of trying to lock down your building, your facility to outsiders, because what's happening then is you have people that have contractual rights. You have your owners that may have a contract for this, or they've paid somebody for this service, and now you're keeping them from coming into your community to be able to conduct that service. Or if you have something that's being remodeled or renovated, or if there's a maintenance issue, those are some difficult questions, as opposed to you have liability there potentially from an owner that's upset from you keeping their vendors and contractors from coming in, versus what I would imagine the association is thinking of is, I don't want outsiders coming in and getting other people sick. And I understand that completely, and protecting yourself from liability, as kind of a related aspect to that. But, in my opinion, I think that people are going out, they're getting gas, they're getting their groceries. I think it's very difficult to say that it was a contractor that came in and spread this versus an owner that may have gone out to Publix to get their groceries and may have contracted, and you had no idea, because they're still going out there, they're allowed to go get groceries, and it's very difficult to prove that. And so I think it's a little more of a tangible, I would say, impact if an owner says, hey, you've caused me to breach my contract because my contractor's not giving me a break, or if they're not sticking by my schedule, and now that owner is somehow in default or some type of an agreement that they have in place, and they could go after the association from a damages standpoint. That's what I'm more concerned with. You could talk to 10 different attorneys and we may give you 10 different answers. I know attorneys that are good attorneys that have may have been involved in some of the decision making where the association has locked down the building and not allowed any outsiders unless it's a resident or a family member in. Do I think that's defensible? I certainly understand where that's coming from, but I think it also opens up liability on the other side. Do you want to touch on that a little bit?
Yeah, I agree with that. There are a lot of essential activities that are allowed under this order. I mean, you would have to be so careful in how you're trying to figure out who can and can't enter the premises, that we don't really think it's a good idea. You're going to, a lot of owners in your governing documents will be granted easements for access for ingress and egress by virtue of recorded covenants, or your declaration of condominium or declaration of covenants. And a lot of times those easement rights extend to owners, invitees, and contractors and so forth. So, to what degree you can interfere with easement rights is certainly questionable under the circumstances. And again, what we don't want is you're prohibiting someone from delivering groceries to grandma, or you're prohibiting someone from fixing the plumbing in a unit that people are, kind of confined to right now. So we would want to be more hands-off. The role should be, that we would suggest, is limiting to posting communications, parroting recommendations of CDC guidelines and so forth, but not really trying to get in between people's access to the units in general.
Yeah. So going through some of the questions, and I think we'll touch back on that a little bit later, or I think we've answered some of them. Yeah. I think this one was, how long can the election be postponed? I think Jim touched on that. There's no guidance for us right now. I've had communities that have canceled it and they're holding off on sending out any subsequent notice. If they were kind of between the first and second notice, they've held off on sending the second notice for setting the meeting again until they feel confident that they could have it in a location, a physical location where people can show up. But we may get guidance later on that the DBPR may come out and say, we feel like you're allowed to have virtual meetings and we will consider that to be valid, under our interpretation of the statute. Again, that could be subject to challenge whether or not the DBPR is able to do that. But assuming that it's valid, that may give us guidance to say, all right, let's retool this a little bit. Let's have a virtual meeting. Here's some software that you can use. Zoom is a software. I'm not paid by them by any means, but there are lots of software companies out there that can have easy to use virtual meetings. We just don't have that guidance right now that we can opine that members can meet virtually right now. So for the time being, there's nothing stating when you have to have that meeting. I would recommend seeing how it goes through the end of this month would be my initial guidance, because we're pretty much on lockdown until May 1st. I think you would have the problem of even being able to find a physical location to have a meeting right now anyways. The next question from Barbara: if the board can decide to increase cleaning but are not allowed to meet without owners, how can they logistically do that? I think if I understand the question is, the board could meet virtually and allow members to participate virtually on that, and the board could vote to increase their cleaning schedule. That would be the way to handle it. So you would post a board meeting, say that it's being held by telephone or video conference. Here's the login information for members to participate in it, and then the board can go through their agenda and make decisions like that.
Yeah, and are there some technical arguments someone can make to try to challenge that process? Sure. Do we still think that process is defensible under the circumstances? Yes. And another strategy we have is when people are trying to attack the process by which our clients are making decisions, you have the ability to ratify things after the fact too, by following the perhaps more appropriate procedures. So, procedural issues we think we can also mitigate on the back end as well.
Yeah. A good question from Ilana is an HOA condo association on-site office an essential business? Like we said, essential, the word essential, or what's included as an essential service or business, is pretty broad. I think there's a couple of things that I've seen in the order, whether it's from, the governor really didn't put any more incorporated from other entities, basically what's an essential function.
Right.
I saw a couple of things in there that would tie itself to management, on-site office being an essential business. I think that if you're an association that directly employs your manager, as opposed to contracting with the management company, there are some employer-employee issues there, and whether or not, if you deem it to be non-essential, and do you have to continue to pay that employee? Can they work from home? That kind of thing. That's more of an employment issue that could come up. So if you have a question on that, talk with your attorney if you're concerned about liability. But I think generally speaking, what we've been finding is I think you could pretty safely argue that an on-site manager would be an essential business function.
Yeah, and aside from whether they are or aren't, I mean, practically speaking, can they perform their job from somewhere else? Most likely.
Yeah. The next question was, or just more of a comment was, a neighboring condo has banned owners from having guests. Also deliveries, cleaning people, only emergency repair people. I can understand where that decision was being made from. Do I think that it opens up the association for potential liability? I do. So I'd be careful. I would want to get an opinion from an attorney. We'd be happy to work with you on it. You can kind of tell what our initial thoughts are on it, but at least you could have it in writing, and how you would go about doing that. If you were to do something like that, at a minimum, I would think you'd want to have a way for them to apply for an exemption from it. So at least then, but now you're setting up a scenario where everybody's going to ask for the exemption, and now the board's going to have to make game time decisions on each one of these requests. So that in and of itself is pretty difficult to do. So it's a difficult situation. We understand if you were to make that decision, I think you'd want to get an opinion from your legal counsel on it in case there's some liability later on as to what you can or what your advice should be on that. So I understand where that neighboring condo is coming from. I don't know that I would advise it under the circumstances. Yeah. Next question is, do we recommend having a members meeting virtual to borrow from the reserves? I know I just mentioned that in order to borrow from reserves, you have to have an owner meeting, but you still have that issue of that member meeting needs to have a physical location from it. Hopefully, and I say hopefully, and I don't know if it's the right word to use, but by the time you are faced with that decision, because I think the economic impact might be a little bit more down the road, because you might be able to get by for the next couple months, even if some people stop paying for the time being. You might have enough in your operating that if you're going to have to make that decision to use reserves, that it's 2 or 3 months from now, maybe by that time we're finding that it's safer to have these meetings and you're not having to worry about still having that virtual meeting. It's a good question though. If you find yourself right now, I mean, somebody asked the question, can we have this in a parking lot? And theoretically you could, if you can properly describe that, where that parking lot is or what the street address is to get there, and say, hey, this is the best way for us to have this vote. Please don't stand within 6 feet of each other, and you conduct your meeting that way. I could see that being proper. Most people aren't doing it that way, and it's usually renting a clubhouse or some type of a commercial rental space that are not open for business right now. So it's practically difficult to find a space if you're not otherwise using an open space like that.
Yeah, if you really need to get into your reserves, that's something you need to coordinate with your management and legal counsel on specifically to see what options are available to you. Otherwise, if you can postpone any membership decisions right now, that's sort of the process we're suggesting.
Just repeating what our answer was about how long the election can be postponed. We don't have guidance for you right now. It's just keeping an eye on really the stay in place order. I think once that's lifted and you start seeing news reports of maybe loosening the social gathering thing, we might feel safer about having these membership meetings in person, which means then you could feel confident about re-noticing the election. But until that time, there's nothing saying, hey, you can only postpone it for this amount of time. So right now you're kind of on a wait and see mode. Does quarantine mean staying in your unit, or can a guest come from out of state to go to the pool? I don't know if I fully understand that question, but I think if you have a guest there and if you're keeping your pool open, one question we've had, well, can we only allow owners to use the pool but not the guests? I think that's a difficult thing to enforce and to differentiate. I think the idea is you're either keeping it open for the people that are able to use it, which is their owners, guests, and tenants, or you're closing it to everybody. I think it becomes difficult if you are limiting who's able to use it and how you're actually going to be able to enforce it. I get that the idea is to try to limit the number of people there and try to kind of practically enforce the social distancing, but I think people just need to be smart and you have to give them the information. And I think one thing you may consider to do is say, look, we are keeping this open because we feel like people can police themselves and practice social distancing, but if we find that that's not the case, then the board reserves the right to close this pool. I mean, I think that could be a notice that you provide to the owners, and I think that would be a defensible position to take if you're not already mandated to close that down.
Yeah, and just as a general matter, as it applies to everyone, participating in recreational activities as they're defined in this executive order are things that you can go out of your unit to do or out of your home to do, right?
Yeah.
So
question is, how can you get your board to back off wanting to take care of the residents, saying it is their responsibility? We are mostly a senior building. So, and obviously I understand if you're in a 55 or older community, or if you just have more elderly residents, I understand that you're wanting to protect them more. And I think the best way is to continue to communicate, provide information to let them make their, help them make their decision-making so that they know what's recommended that they should stay in place. Where we're just worried about is if we're saying we are going to help you, we are going to make sure that we, are wiping down the elevators after every use, all the buttons on the elevator, for example, or we will always be there to make sure that everything is as sanitary as possible. Because if somebody were to contract it and to die, or something were to happen or health complications from it, again, that's where we came into. Somebody could say, looks like you failed in your duty that you took on to keep my client safe. That's the difficulty there. So I think information, continuing to stay in contact with them, reminding them, keeping up to date on news from, and I joke about this, but what, credible news sources and information that you can provide to people. I think that's the best thing that you can do as an association right now. But I wouldn't go so far to say that you are undertaking that duty to keep them safe, even if you want to, of course, which is understandable. Is it reasonable for a condo on-site maintenance worker to have a procedure for not entering a unit? I think if that's a question of if somebody asks for an on-site maintenance to come in, and if the maintenance worker, I'm not sure if I fully understand that question. Jim, do you?
Yeah, it would seem strange to me to have an on-site maintenance personnel doing work in a unit anyway. If you have an on-site maintenance personnel that actually helps unit owners do things to their unit, I'd like to talk more about whether that's a good policy in the first instance, right? You're probably taking on a lot of liability.
Unless there's some additional contract or something that provides for that service that the association may not otherwise provide.
Right. It sounds like a pretty unique situation. So, but aside from that, it's kind of tough to answer that question in the abstract because that's a bit of an unusual situation. I don't know how to answer that question.
Yeah, for the person that posed that, if you'd like to email us and if we can get information or talk with your attorney, but we'd be happy to try to answer it, maybe get a little more information after the fact. I think one thing that wasn't asked, but I think is important to note, is if you become aware of somebody that contracts the disease, for example, and we've had these questions, what if we know somebody, whether it's on the board or somebody in the community, what should we do from a communication standpoint? And our advice has been, don't name that person unless they have specifically authorized you to do that. And I would get that in writing, even if it's by an email. I could maybe see somebody saying, look, I just contracted this and I was I've been trying to practice social distancing, but I was at these locations in the community. Please let people know in case they may have been around me at the time so that they understand that. I would wait for them to give you that go ahead. Aside from that, if you don't have that authorization, you can maybe communicate to say, we've been made aware of a resident that's contracted it. As we've been advising, please try to practice self-quarantining, only going out for essential services, and understanding that while we have cleaning schedules, you are, leaving your unit or your property at your own risk, and please stay safe. So I think it's okay to communicate that, but I would never, I would probably say never communicate the name of the person unless they have given you permission to do so, because there are privacy issues there. There's a potential, from a defamation standpoint, if you heard that from a neighbor and that person didn't actually have it, that could give rise to liability. So I'd be careful about doing that. But if you become aware of it, I think it's proper to communicate it generally that you're aware of a case and you're reminding people to practice the quarantining and the safe social distancing. And we will continue to provide you with information as it becomes available. I think that's the best way to handle it. Let's see. Okay, I think this is our last question here. If your board still wants your VCC to have a Zoom meeting so like a finding committee. So that's a good question too about violations. We've had that come up. What should you be doing about violations right now? I could see communities, I know some of them have backed off for anything that would require them to go out and purchase something or to go out and get something to correct that violation. Communities by and large are holding off on some of their violation activity. Now, if it's something where, one of the most frequent ones, if you live in a single family HOA where you have a garbage can, if people are still leaving their garbage cans out for days at a time, I think it's okay to send them a letter. Now, they may be doing that because there's some health issue or something where they haven't been home, they had to leave, or they forgot to bring it back in. Of course, address those on a case-by-case basis. But by and large, I don't see the liability or the risk to the association of holding off on violations for a month or two, unless it's something that's been in violation for closing on 5 years, because then you have a statute of limitations issue where you can bring a claim. So if it's been an ongoing violation that's not tied to this and that's been in violation for some time, that may be different. But for the most part, a lot of communities are holding off on their inspections, or they're holding off on the fining and enforcement. If it's for something where, you don't want to force somebody to go out to Home Depot if it's an elderly resident, for example, that's in violation, and now you're asking them to go out to Home Depot and buy something and they might expose themselves, for example. Like, I would wait a little bit, have a little bit of leeway there, and then we can get this process started again. If you still choose to go through with the fining meeting, I think you could potentially have that virtually. I think you'd want to provide advance notice of the way for them to attend, and understand that if they have some objections to having it virtually, because they feel like they're not able to provide you with evidence as to why the fine shouldn't be imposed, or they want to have a witness and it's not easy for them to do it, tell your committee to kind of gauge that on a case by case. But if there's some question as to whether or not they're getting a quote fair shake for this violation hearing, consider just moving it back a month or two when you feel like you could have it in person. That fine doesn't necessarily go away. What you're doing is just pushing back, and you're showing that you're being accommodating under the circumstances. But if you chose to have a virtual enforcement meeting, I think that that would be proper. Just make sure that the people that are subject to the violation or the fine are able to participate freely with providing information, and that they can be heard clearly and all that kind of stuff. Let's see. The sheriff of Pinellas County issued an order on pool closures except for private homes. And the Tampa Bay Times article had stated that the sheriff repeatedly stressed that the order is voluntary and that the county is not under a mandatory lockdown. Does this mean that we can use the pool if we choose to do so? So I think from what I'm reading there, then that's a recommendation. It's not a mandate. If there's not anything else mandating it, I think you can choose to keep the pool open. And again, we can't tell you yes or no, but if you choose to keep it open, but provide some type of warning language on the sign saying you're using it at your own risk, I think that's certainly proper under the circumstances.
Yeah, so we're not aware of any mandate that a residential community association close its pool.
At least from Pinellas there. Yeah, if that's what the sheriff is saying and that's where they're coming from, right? Is it the master board, this is from Merrill, is the master board's responsibility to advise the community that there is something in the community with the virus? I think we just addressed that, which is you don't have, I would not name the name of the person, but you can make it generally aware of it, and that they're, again, reminded to practice, have safe practices, stay indoors whenever possible until we can ride this thing out.
Yeah, see, we're dealing with a relatively unprecedented situation. So the nature of the association's obligations under these circumstances are debatable and arguable.
Yeah.
So whether objectively you would have a duty to inform or notify, whether that exists, irrespective of whether you purport to undertake that duty, is something that's arguable and questionable. So we're suggesting, as a matter of practicality, don't name names, but consider sending a communication to residents.
Yeah. And Robert, if you like, I know if you want to respond to Kathy's question here.
Yeah, I would like to. There's a question that they have no website at their condo due to a change, and they want to know how the board can have a new company come in on the scheduled April 11th date to switch us over. That is definitely something that your management company should be able to do for you to get that website up and running. Kathy, if you'd like to email me separately offline, I can help you out with that as well. And you should have my email, but if not, it is rtauberjr@vestapropertyservices.com. And look for yours in here as well, and I can send an email out to you. So just in closing, I just want to take a minute to thank Ed and Jim for providing your time and all this information. I know that there are a couple other questions popping up, and I'll do my best to answer them as well, just so we can get through ending this meeting. I'd like to thank all the board members and all the attendees. I hope that the information was useful, that you are going to take some of this stuff back to your boards. And if you have any questions that were not answered, or you have anything that pops up, questions always come into mind after these meetings, please feel free to email your property manager or me directly. We will get you all the answers that you need. And we just hope that everybody stays safe and healthy out there and try and maintain that social distancing. Ed and Jim, appreciate your time. Thank you very much.
Thank you. And I would say for the last couple of questions, if I'll just answer those real quickly. We had those, and if we'll end it after this. Obligations and liabilities with maintenance workers. We kind of talked about that. There may be a contractual issue there from an employment standpoint. I would talk with your manager, talk with your attorney from an employment standpoint, and just for a decision that you make regarding your maintenance workers. And then can you limit the number of people in the pool at any one time? And there's rules in place already that you could do that from a health and safety standpoint. If you're doing it in response to the coronavirus, I could see there being a reasonable rule of not differentiating necessarily between owners, guests, and tenants, but more of a general capacity limit. I could see that being an enforceable rule as well if you were to change your occupancy limit.
Yeah, I think, yeah, so just generally limiting the number of people in the pool, sure, but I would be careful about distinguishing between owners and tenants and guests. I think maybe a reasonable guest limitation is something that would be defensible even outside of the COVID-19 situation.
Right.
But, outright excluding guests, I think is where you come into a little bit of more difficult territory.
Yeah. So with that, Robert, thank you very much for organizing this, and for everybody on here that's still on. You have a great, working with Vesta is a great management company that they provide you with these educational opportunities. I know our firm, we have your contact information. If you'd like to reach out to us, we're happy to provide you with any further guidance. And we will be doing some more of these webinars on more specific topics, or if there's additional guidance that comes out that changes what we've told you today, we may choose to have another webinar. So we'd be happy to have you attend at a future date too.
Thank you again, guys. I appreciate it.
Thank you. Very welcome. Have a good weekend, everyone.
Thank you.